फिर आगे देखे तो मतलब क्या है? ओहो,
Yes. How
lots
much time will take?
for complete at least 1 hour. 45 minutes.
Then I will hear you on Monday.
Monday.
In the meantime, my lord, can I seek permission that I can file my written notes of argument? with
Yes,
the
yes,
elements?
yes, yes.
45 minutes I will take. And I will conclude in 1 day.
Part heard
Lots.
Monday.
Grateful lots.
Because I have to leave
My lord.
for Jarwa Basti and
Lordship can Lord,
Slow speed. Mr. Govind is wishing your lordship best of luck. Yeah.
It's very horrible, my lord. The road is very horrible.
He just.
yeah, I heard.
Last week I came back from Miami after attending the call. But my lord is lucky that there is no rain today. So like,
Good day. My lord is
Good
hoping
journey.
to reach.
Memorable journey at least.
My lord is hoping from Manipur today. Or
No.
will be a night out at Rangoon?
Night out at Mayabandha.
then it's
In the meantime,
by 7:30, after Rangat, it is.
after Rangat, it is
It's good, it's good, man. It's good.
a stretch of 50 kilometer.
No,
like
my
that.
lord, it's more than 120 kilometers.
120 kilometers.
No, the stretch that your lordship is talking about.
What do you order?
Once you cross the ferry on to Barata, Barata and Rangat is ferry. But after that, that second Jarwa protection area is there, what they call Kultala and then Badaji, gate number 3 to gate number 15. Once that is passed,
Would I able to meet Jarwa or not?
Yes.
on the way.
My lord can see on the way.
Are they friendly?
Yes, they are friendly.
I'm sure.
They'll ask for pan and all those things.
Hey, we like
That's
it.
it.
Okay, ये करो. And वही पट्टा है.
My lord, OP2. My lord, the contention of
Petitioner, my lord, senior Mr. Shamanto.
May it please your lordship. Milord, your lordship can hear me, milord?
Oh. Yes, you are audible, please.
I'm grateful, milord. Milord, your lordship will see that we have challenged an order by the appellate authority, which is at page 48 to 49, milord.
That is Annexure P10, my lord.
Just a minute.
Annexure P10, milord.
Annexure P10. Page.
My lord. Page, milord, 48 to 49.
Yes.
Now, my lord, this is affirming the order passed by the final order passed, milord, at page Annexure P8, page 33, milord. এখানেই আছে মোটা বই ওর মধ্যেই আছে এটার মধ্যে Annexure P8, milord.
P8.
P8.
Yes, milord. P8.
Yes.
Now, milord, this is under the provisions of Rule 168. They have invoked the provisions of Rule 168 of the
What the rule says?
milord 168, milord. My learned junior will hand over the rule, milord. It relates to, milord, the erection or re-erection of a building
Yes.
without sanction as required under subsection 1 of section 162.
Yes, without sanction.
Now, milord, here what has happened is, it is that a temporary structure which has been built by the petitioner for very temporary in nature, milord, not an RCC structure, etc. At the behest of a complaint by someone, a third party,
But Mr. Rakesh Kumar is for the PBMC in this matter, my lord. He is on his next before court number 1, my lord.
So let me proceed. You may take note of.
My lord, that I can take.
I am grateful, milord.
Yes.
Now, milord, here what they have done is, they have done the entire proceeding behind our back, milord, without giving appropriate notice. What is the complaint, etc. Nothing has been given. Everything has been done in violation of the principles of natural justice, milord. And there are provisions, milord, in section 168 itself, milord, that the lordship will kindly come to 168 once again, milord. The second proviso to F, milord.
Yes.
Provided further that the municipality may, instead of requiring the alteration or demolition of any such building, accept by way of compensation such sum as it thinks reasonable. My lord, my humble submission before my lord is this, my lord. I'm sorry.
এই রুলের ইয়ে নেই আমাদের কাছে Yes. Yes, sir. Continue.
My lord, your lordship sees the entire proceeding is behind my back. We
Yes.
preferred.
This is your first point.
Yes, my lord. But the first point is that it is again in violation of the principles of natural justice. Entire action taken on the basis of a complaint by a third party who is not affected in any way, who has no locus standi. The second point, my lord, is that the structure is a temporary structure, not a permanent one.
Yes.
No report was filed. I would beseech my lord, let them say, yes, any report was prepared, anything was handed over, nothing has been done, my lord. And my lord, last of all, my lord, that the municipality has a power of relaxation. And if it finds that for a temporary purpose something has been done, it does have the power not to demolish on such terms as it may impose upon me, my lord.
Yes.
So therefore, my lord, I was humbly beseeching your lordship, my lord, the appellate order requires to be considered by your lordship, and orders passed, let them reconsider the matter in the light of the materials that were placed before it. Because otherwise, my lord, if it is demolished, my lord, nothing will remain. My entire petition will become infructuous.
No, your land is falling under the airport authority.
My lord, we have made applications. That is also there. We have made applications that is being considered by the authorities.
This is the main ground.
My lord, in that case, my lord, the authorities are sitting over the matter. Both the authorities are sitting over the matter. We have asked for conversion. We have asked for making application before the airport authority. Subsequently, my lord, definitely after, my lord.
Where is the provision for conversion? Where is the provision for conversion?
My lord, we have made the application conversion to that provision is there, my lord. That provision is there. Your lordship can take it from me. That the authorities have the power to change the nature and character of the land. If it is for house purpose, it can be converted to commercial purpose. We have made that also. That application is pending. All these are pending, my lord.
Where
We have given that in our appeal, in our statutory appeal before the appellate authority. We had given this in the stay application. Everything has been given. Notwithstanding that, my lord, the appellate authority has passed the order, no demolition.
No, can authority has power to change the nature of land,
Land, yes, my lord.
and can authority declare a land of airport authority?
No, my lord. I'm not saying that, my lord. I'm
No.
only saying, my lord, the conversion is one part, and the other part is we have made an application before the airport authority. Kindly grant us permission. That is also pending, my lord. I'm not saying that airport authority land, the other authority has power. Can't be. That would be absurd if I say that, my lord. I'm only saying this, my lord, that an application has been made before the airport authority. They should also consider my application. And pending that, my lord, why should I undergo an order of demolition? I'm
Where-
only asking myself this question, my lord. Let them consider, my lord, no one, and it's on the basis of a third party complaint who has no locus standi.
No, third party can make complaint. This is not a strange for you. Third party may make. So,
My lord, even assuming, my lord, that is there. But, my lord, ultimately, if the principles of natural justice are violated, if, my lord, my applications are pending before the authorities to be considered by them, in the meantime, my lord, a one-story structure, temporary in nature, your lordship may direct any authority person to go and see the construction and give a report before my lord. It will take only one day, my lord. Today is Friday. Your lordship can take up the matter on Monday again, if necessary. But let them file a report and say, what is it?
matter will face on Monday. It would be better to hear you physically.
Physically, my lord.
And in the meantime, you file all the relevant documents,
Lordship.
relevant law, under which you have made prayer before the different authorities.
My lord, my lord. My lord, in that case, my lord, your lordship is there till the 20th, my lord. I have a matter in the Supreme Court probably on Monday, my lord. In that case, my learned junior will pray for a short adjournment on that day and I'll come back before my lord.
Okay, no problem.
I'm grateful, my lord.
We'll accommodate.
20.
I'm grateful, my lord. I'm grateful.
You take that. So in that condition, I am fixing it on Tuesday.
Milord, actually problem is nowadays Supreme Court, whether it is 9th or 10th, it's coming nowadays. It is not that easy. Earlier it was very easy. The date was fixed and it was coming. Nowadays we are in real difficulty, Milord. We
Okay.
don't.
Hmm.
Lordship will keep it on Monday, Milord, and if there is a difficulty, Milord, we'll. Otherwise, I'll come personally, Milord.
Thank you. Thank you.
I'm grateful, Milord. I'm grateful.
But I am for the item 5, my lord. But I say, my lord, this application is, my lord, premature because, my lord, if your lordship will see the prayer, my lord, what they have prayed is that.
You are for the petitioner.
I am for the respondent. I am for the labor department, my lord.
So first,
Your Lordship,
the petitioner
the
submit.
petitioner was working as daily rated bus conductor, Your Lordship, after which he was disengaged from service by the respondent authority. Following which he submitted an application before the respondent authorities to hold conciliation proceedings.
Under Industrial Disputes Act.
Yeah, I did.
Conciliation proceedings was held, and after which a report was submitted stating there is failure in the settlement. There was no settlement arrived. After the report under section,
Settlement in respect of your
Dispute.
the industrial dispute between the employer, that is the department, and the.
what
employee is the
issues are
petitioner.
there? Issues of dispute was your disentitlement, disengagement
Disengagement from service, Your Honor.
from service.
Yes, Your Honor. After the conciliation proceeding was held, a report under section 12 subsection 4 was submitted by the conciliation officer to the appropriate government. After the report was submitted to the appropriate government, the appropriate government has a duty under section 12 subsection 5 to refer the particular industrial dispute to the labor court or any other appropriate authority. In this instant case, the decision whether to refer this particular industrial dispute to the labor court was not taken. There was no certain decision taken by the appropriate government. So due to this inaction of the appropriate government, who is the Lieutenant Governor herein, the respondent number 1, the petitioner has approached this honorable court.
Appropriate government did not refer your report to labor court.
Yes, Your Honor.
This is your view.
Yes, Your Honor.
My lord, under section 12, subsection 5 of the Industrial Disputes Act, it is discretionary whether to refer or not to refer.
Yeah.
But my lord, a decision definitely has to be taken. So my lord may direct them to take the decision, my lord. They'll do it, my lord.
It's under
It
consideration.
is under consideration, we'll do it, my lord. My lord will dispose it off to the director.
Okay. Sit down. The petitioner
कौन सा 5 नंबर है इसमें तो मैं जानना
was disengaged from his employment as daily rated bus conductor in the Department of Directorate of Transport, Andaman and Nicobar Administration on 10th July 2015, long back.
He was engaged on 10 July.
Oh, engaged.
Disengaged on 8 September.
8 September 2021. 8 September 2021. The dispute was referred for conciliation in consonance of the section 12(4) of Industrial Dispute Act. The conciliation proceeding was filed and report was sent to appropriate government. But the said report was not referred. But the said dispute was not referred dispute was not referred to labor court. In consonance of section 12, subclause 5 of the Industrial Dispute Act. Learned advocate for the respondent is to direct to who is the respondent? To the respondent authorities. To consider on his prayer. एर आगे ही लिख दो कि the provision or हाँ केटे दो the provision under 12 subclause 5 of the IDA is discretionary in nature and authority is not bound to refer all the disputes to labor court. This is your
Yes.
and authority is not bound to refer all dispute to labor court. However, respondent authority may be directed to consider on his grievance. Accordingly, the respondent authorities, more than one authority or two, who are respondents? Lieutenant government authorities are direct.
The respondent number 2 will be required, because lieutenant governor has a.
The lieutenant governor is the boss of all authority. He may give direction. I am not giving direction individually to any authority. The respondent authorities are directed to consider what is your prayer? Making to consider on the prayer of writ petitioner, time in accordance with law, the writ petition stand disposed of, urgent review.
Lordship, that is direction charge also with regard to the time in which the decision will be taken by the respondents. Because already with respect to conciliation, they lingered this for a
Yeah,
long time.
what time?
Why not be grant 3 months?
3 months. Within 3 months from the date of the communication of this order, learned advocate for the respondents are directed to communicate this order to.
Why not let the direction be on the petitioner? Usually petitioner, it's very difficult for us. Let it be.
Since they are represented by you, that's why.
We will communicate in any case, but let them be given the liberty.
Okay. Learned advocate for the petitioner. Petitioner, respondent केटे दिन. Petitioner is directed to communicate this order immediately to the respondent authorities. Accordingly, the instant writ petition stands disposed of. There is no order as to the first. Urgent photocopy. Yeah, thank you.
Sir, herein I am the petitioner in person in item number 6. This matter is about the blocking of my YouTube channel. Actually, I am a 2024 Lok Sabha MP candidate. Sir, I was running a YouTube channel by my personal name to disseminate information in the
Respond.
interest of public residents of Andaman and Nicobar Island, as there are no national media present there. So what happened is suddenly after the election, my YouTube channel has been blocked, and when it was blocked, I have followers of a subscriber of more than around 10,000. Sir, the as per the Supreme Court judgment in just in Anuradha Vasin versus Union of India case of 2022, it said that YouTube performs a public function and is bound by the Section 79 of the Information Technology Act 2000, as well as the Information Technology Intermediary Guidelines of Digital Media Ethics Rule 2021. And it can't terminate the YouTube channel. And it gave the criteria that I have violated some guidelines of the YouTube, which says that because what I found is that there is no violation from my side, any principle of the or rule set by the YouTube. Still, my account has been blocked, or what I say is terminated. I can't even open my YouTube account. Uh, Sir, in this matter, they said that there is a copyright violation. Sir, the I have shared a video clip of the statement of our ex-MP, four-time ex-MP Vishnupada Roy, who made some comments about the residents of Andaman and Nicobar Island, shared with added expression. The copyright law of the US says then when a video is shared or clip is shared with added expression, it cannot be called as the violation of a copyright law. But still my account has been blocked, account has been terminated.
If under the respective act, there
Yes.
is you may seek relief under a specific act of yeah, a proper provisions under the Copyright Act. How the
Sir, I have submitted many representation before the Google, before the YouTube, that this is the violation because the similar judgment, there are similar cases which is been
there is provision in Copyright Act,
yes.
and your grievance may be settled there.
Because may I just say that, Milos, I appear for respondent number 1, Milos, that is been included as Google India, Milos. Milos, I just wanted to point out, Milos, kindly see the prayers that have been made in the petition. There's all the reliefs are being sought by against me per se, Milos. Firstly, Google India is not the correct entity, one, Milos. Secondly, Milos, these are all, I'm a private entity, Milos. So all the reliefs that have been sought, they have to be, it can't be adjudicated in a writ petition, Milos. We can't have a fact-finding inquiry, Milos. Law is settled with respect to that. Milos,
yes.
Sir, there are similar cases, the Supreme Court and High Court.
Milos, I will show the line, Milos, Milos are very well aware of the fact that there are line of judgments by the Supreme Court saying that, Milos, there can't be a writ petition that would be maintained. Milos, I don't function, there is no public function, Milos. I provide a platform. He can go to any other platform, Milos. There is just not one platform that is available. So that is there, Milos. So per se, I'm a entity.
Respondent number 1. Who is for the Ministry of Electronics and Ministry of Information and Broadcasting? Where is the affidavit of service?
Sir, the affidavit of service I have already submitted, sir.
But notice has not been properly served to the respondent number 2 and 3. This is through email.
Yes, sir, I have sent through email.
You are directed to send notice upon respondents through a speed post with AD.
Sir, it will take time, sir. It will take time. And what happened is, sir, if it is get delayed, because there YouTube some criteria is there. If my YouTube channel is suspended for long, I may lose the viewership.
That in absence of the respondent, you
Yes.
are taking relief against the person
Yeah.
not present before the court. How court will pass order? Behind the back of the respondent. First
Sir,
you, the
sir, I,
then thereafter will proceed.
sir, it is allowed to, is there a Supreme Court judge, it is allowed to send the notices via mail, via mail it is allowed. I have sent it properly because the Google have joined already, that why the other two parties are not willing to join.
There is no any report as to whether your notice has been received by him or not. Only sending message is there. Whether they receive, nothing is there.
So an order may be passed, and order may be passed, an order may be passed, that I'll send you the order copy. And it will be better that if I send you the order copy then.
Yeah, take down. You are appearing in person.
I am appearing in person, sir.
Yeah. Learned, yeah. Petitioner appears in person. Respondents. Respondent number 1 represented by
Mr. Rakesh Kumar would be there, my lords.
And then Mr.
Roshan.
Ahuja.
Rohan Ahuja.
None, none appears. Yeah, respondent number 2 and 3 is not represented. नाम लिख के नहीं लोग जाओगे respondent number 2 and 3 is not represented. Petitioner is directed to serve a notice on respondent number 2 and 3 through a speed post with AD at their addresses mentioned in the writ petition and file affidavit of service within 3 weeks. Let this matter appear before the next circuit bench.
Grateful, my lords. You know, the next date, my lords?
Yes. Who is in 7?
Please, my lord, I'm appearing for the petitioner in serial number 7 and 8. My lord, they both are connected matter. Am I audible, my lord?
Yes, yes, you are audible.
Yes. My lord, both the matters are connected. The facts are same. The accused person in one is the husband and in the other petition is the wife. So, my lord, if I may request, my lord, to only refer to serial number 8 petition to avoid, because the facts are same in both the matters. My lord, I will point out the annexures from serial number 8 petition.
Nina Ramesh Kumar Prakash But parties are different in both the cases.
My lord, they are husband, the accused persons are husband and wife, and the petitioners are father and daughter. The facts are same. This is arising out of 138 proceedings. There were two different checks issued by her husband and wife. Therefore, there are two separate petitions, my lord.
Yes. So you are
Yes.
petitioner.
Sorry?
You are for the petitioner.
Very well, my lord. Yes, I am for the petition.
Who is for the respondent?
My lord, the affidavit of service has been filed for the accused persons. The post has returned back with a remark as unclaimed.
Then it is not proper service.
My lord, my lord,
Unclaimed.
my respectful submission. It is a good service because it is unclaimed. It is that I have relied upon judgments of Honorable High Court and Supreme Court that unclaimed is good service.
Unclaimed.
Yes, my lord.
Kumar Kataria.
Ramesh Kumar Kathiria.
Kataria.
My lord, may I begin? If my lord may permit me.
Just a minute. Ramesh Kumar Kataria in item number 8.
Yes, my lord.
And what about the item number 7?
My lord, Hina Ramesh Kumar Kathiria. She's the wife.
Whether she is service of
My
on
lord, same report. Same. The address is same for both both for the respondents and both the petitions.
घर 5 साल से बंद है. This is the report.
Yes, my lord, because the correct facts are that they have
Unclaimed.
during.
There is difference between unclaimed and unserved.
My lord will see the envelope. It is come back with the remarks unclaimed.
No, it would not be a good service.
My lord may hear me for 2 minutes. My lord, the same subject matter I had approached the honorable this very high court. My lord will see page number 73. My lord, I had filed the revision before the sessions court, which order I'm challenging. The sessions court, I prayed in the sessions court also when I filed the revision, I served the respondents, accused persons. The service came back with the remark unclaimed. Sessions court directed me to take steps to serve them. I challenged that matter, that order before this court. And this court has set aside that order, my lord, because this court has treated it as good service, my lord.
Unclaimed means the person was present and he avoid to receive your notice, that would come under unclaimed. Since there was no person was living there since last 5 years, how a service can be effected?
Exact matter I had approached this honorable court. And the honorable court has held that yes, it is good service since the accused persons have absconded abroad during pendency of the trial.
Please cite that order.
Please, my lord will see at page number 75
Of
the serial number 8, my petitions, page number 75.
you are husband and wife. Do you not aware about the present residential address of your counterpart?
No, my lord, they have not updated to us because there is a red corner notice issued against them. They have absconded abroad during pendency of this criminal trial. To evade these proceedings of 138, they have absconded abroad. There's an LOC, my lord. Their passports have been impounded. There's a red corner notice issued. All of this was brought to the notice of the Sessions Court. Yet the Honorable Sessions Court held that the notice is not complete. I challenge that order before this Honorable Court. This Honorable Court held that no, this notice must be treated as good service in view of the law laid down by the Honorable High Court and Supreme Court, my lord. My
You are
lord will see the.
I'm for the petitioner.
petitioner. And no one is for respondent.
State is.
No, state is there. What is in this case?
My lord, the issue is very limited in this case. What has happened is the accused persons were evading the arrest when I filed the 138 proceedings. Then they were arrested, they surrendered, they were released on interim bail on the undertaking given by them that they would comply and they would repay the entire check amount. They flouted that undertaking and they never appeared before the trial court in the 138 proceedings. My lord, thereafter proclamation was issued. After proclamation, 1 month time was given. They did not appear. They were declared as proclaimed offenders. Therefore, I filed an application under section 174A requesting the Honorable Trial Court to direct the SP Aberdeen to register an FIR against the accused persons because it's a clear offense under section 174A if despite issuing proclamation, if accused fails to remain present. My lord, my application was rejected by the trial court. I filed a revision in appellate court, sessions court. My revision was also dismissed. Therefore, I am before this honorable court. My lord, the brief question is whether if an accused fails to remain present after him being declared as a proclaimed offender, whether he is liable for prosecution under section 174A of IPC. If I may take my lord's attention to the application filed by me before the trial court.
It is better to appoint someone from the panel to represent panel. Where is the list of advocates? Someone has to represent, huh? Otherwise, if he is avoiding, then so let this matter appear on Monday.
My lord, I have some personal difficulty on Monday. Can it be kept on Wednesday?
Okay, Wednesday.
Very good.
I'll pass some direction to learned registrar to engage someone from the list of the advocates. Let me see.
Very well, my lord. My lord, in my respectful submission, this service must be treated as good service, but it is up to this honorable court.
Yeah, I do agree with you.
Yes.
But when a person failed to claim your in that condition, there
My
was
lord,
no person was residing there.
my lord, but the accused has willingly failed to accept it because they have not appeared in the 138 proceedings. They have absconded to Africa only to evade these proceedings, my lord. In view of that, whether he is eligible for any legal aid.
In that case, it may be, since he is willingly avoiding and
Exactly.
that case,
Exactly, my lord.
I considering on the engagement of some advocate from legal aid to represent him.
Very well.
Okay, Wednesday craft. Next.
I'm obliged, my lord.
Thank you.
My agent for the respondents. Senior advocate Anjali Nag appears on behalf of the petitioner. Let it be fixed on this coming Wednesday.
Wednesday.
These are for the same year.
My lord, my son is appearing for the petitioner, my lord. In this case, my lord, I am seeking leave to amend the proceeding and the body of some parts.
You are?
For the petitioner, my son is appearing for the petitioner.
What amendment you saw?
My lord, there is some clerical mistake in the proceeding, my lord. Due to oversight of we have not correctly mentioned the respondent's name. For that purpose, we pray.
Yeah, Central Bureau of Investigation.
My lord.
Yes, leave is granted to correct the name of respondent in cost title. Yes. Then, are you ready?
My lord, we have to file amendment caution, my lord, for that purpose. Time.
By
By Wednesday, my lord.
learned advocate for the respondent prays for leave to amend the cost title of the name of respondent. Leave is granted. Let the necessary amendment. Leave is granted. Let the necessary amendment in the cost title of the respondent be carried out by Monday. Let this matter appear on Wednesday. Would you be available?
Most probably I'll be there, man.
Off and on, you are leaving to mainland.
On the last occasion,
This matter is very soft.
on the last occasion, I was not there, my lord, because my son appears in the CLAD exam on Sunday. So I was at Calcutta. So on Monday and Tuesday, I was not there.
But this last several order.
No, my lord, I am really shocked to see that because on the last occasion, it was the prayer of the petitioner for adjournment.
Why not you appear on Monday? Yeah, Tuesday.
Coming Tuesday, my lord.
Yes.
By Wednesday, it can be possible. We have to take instruction, we have to signature of.
So let me first hear.
No, they have all the petitioner. They have to.
You are petitioner.
No, they are petitioner.
We are
I'm the respondent. I'm the respondent.
The learned advocate for petitioner. Learned advocate for the petitioner. ওই দিক আছে ঠিক আছে Here, let this matter appear on Wednesday. Matter is very short.
My lord.
And 2 FIR was initiated.
The issue is that, my lord, they say that the transaction are same. And there is 2 FIR. But fact remains that the first FIR was for disproportionate of assets. Whereby during the course of investigation, we found out that certain amount was transferred in the account of the wife and 2 sons. So they were added as an accused. Second FIR came in existence because that money was transferred by the contractors, 3 different contractors. So it was a germination of 3 new FIRs. But then, my lord,
Okay, we'll hear you.
My lord, I'm ready, my lord.
My lord, from 10, item 10 to
10 to 18.
18 connected.
There are 30 of 24.
Item 18 তো হয়ে গেছে
Respondent.
ও আচ্ছা Yes.
Respondent.
You are called respondent. Respondent estate, yes.
My son is appearing for the petition.
Yeah. What is in this matter?
My lord, we are coming for this honorable court for seeking of an for causing of an FIR. My lord.
Why? What defects are there?
My lord, may I please, my lord?
Hmm.
My lord, on 17/12/2023, my lord, and a complaint was made, my lord, by the airport authority before the police station.
By?
Airport authority, my lord. Airport authority, my lord.
Airport authority. Yes.
On the ground that at the time of screening of the luggage bag, my lord, they have found one ammunition, my lord, one bullet. On the basis, they made a complaint before the PS authority regarding the same, my lord. And thereafter, they chalked an FIR under section 25 1B A and 25 1B G. Thereafter, the accused person apprehended and he was produced before the court, and thereafter he get the bail, my lord.
Yes.
My lord, here the question is regarding the
Yes.
the possession, my lord. Here, the on the complaint and in the FIR, my lord, there is clear cut mention that the one ammunition was found in the luggage of the accused person allegedly in the during the screening of the bag, my lord. So here comes the question, my lord, whether he was in the conscious possession, whether he has the intention or the knowledge about the bullet or not, my lord. This has been dealt in the various of judgment of this in this Honorable Supreme Court and the various High Courts, my lord, where it has been held that, my lord, if the intention of having the ammunition is not there, my lord.
So these are the tribal issue, na?
My lord, no, my lord. My lord. I
Such question.
No,
you are correct.
My lord.
You are correct, but such question can be determined after recording of evidence.
My lord, I can place the judgments, my lord, where the same facts of circumstances, well, it has been caused, my lord, by this Honorable Court and the various other Honorable Court, my lord. I will accept the time, my lord. My lord, here, the same circumstances, my lord, will appear, my lord, which says that on the time of screening,
So you are relying on.
The judgment, my lord. And
Yes.
there are other judgments, my lord, also, my lord.
Yes.
Here, my lord.
Cite those judgments.
Here, my lord, there are one section in the Arms Act itself, my lord, which has been protected me, my lord. If section 45, subsection D of this Arms Act, my lord, which says, my lord, that may I please, my lord?
Yes.
Section 45. So, subsection D, which says that act not to apply in certain cases, my lord. If the acquisition, possession, or carrying by a person of minor parts of arms or ammunition, which are not intended to be used along with the complementary parts acquired or possessed by that or any other person.
Section 35D.
45D, man.
45.
45D. It has been held in this judgment.
Arms Act touches. Nothing in this act shall apply to.
Man. Subsection D, man.
Subsection B.
D.
Yes.
Uh,
B or D?
D for dog.
Yes.
Whether the
acquisition, possession, or carrying by a person of minor parts. By a person of minor parts of arms or ammunition, which are not intended to be used along with complementary part acquired or possessed by that or any other person. Yes.
It has been held in this case, my lord, which I have handed to my lord. The paragraph 23. May I please, ma'am?
Yes.
In the present case, the controversy revolves upon the fact that whether one leaf cartridge comes under the category of minor ammunition as provided under section 45D of the Arms Act, my lord. This has been held.
Controversy revolves around the fact that one live cartridge.
Ammunition.
But what recovered from
Ammunition, my lord.
ammunition only.
My lord. These are same, my lord.
Yes. Yes.
My lord. From paragraph 40 onwards, my lord. The relevant would be 41. It is also pertinent to mention here that the learned APP has argued that the life cartridge is not single piece and there cannot be any minor part of the same. In the eventuality, for my satisfaction, I directed him to produce this ammunition in the code. On production, I found that only cartridge container was produced and same was without powder and cap. Therefore, whether the cartridge with ammunition, live cartridge comes under the minor ammunition set, whether without powder can be said that the container is minor ammunition. Single live cartridge cannot be used for any third purpose without firearms. Value of the same is in the market is also not attractive. It cannot be used for any third purpose. If the intention of the petitioner was not of either of the purpose mentioned here above, then he cannot be held guilty and punished for the charge framed under section 1. Thereafter, my lord, he had been cross my for the reason that the only single minor part he cannot be charged with, my lord. They are getting up.
How many ammunitions were
One single, my
Single.
single.
Okay.
It has been this judgment has been relied in this judgment also, my lord. My lord, this is the Delhi High Court judgment, wherein the judgment has been relied upon.
Yes.
In para 8 months. In para 8, it has been held that when only a single cartridge or bullet is found in the possession of the offender without any other suspicious circumstances, such possession shall not be enough to prosecute the offender. As a solitary cartridge is a minor ammunition which is protected under section clause D of section 45 of the Arms Act, my lord. Here is also a similar circumstances where the affair was quashed, my lord.
Yes.
Here is the Bhajanlal case, my lord, which laid down the circumstances when the affair was will be quashed, my lord. In guidelines F, my lord, page number 6, my lord, paragraph 8.1 F, my lord.
Paragraph? Yes.
F, my lord.
Guidelines number?
8.1. Paragraph 8.1.
Guideline number F.
My lord. Page number 6.
Yes. Which guidelines you are quoting? A, B, 8.1, A, B, C, D, E, F. F.
Whether there is an express legal bar engrafted in any of the provisions of the code or any concerned act to the institution of continuance of the proceeding, whether there is a specific provision in the code or the concerned act providing efficient redress of the grievance of the aggrieved party. So this judgment which gives the power of this to the honorable court to quash the affair and frame certain guidelines by if any of these offense has been circumstances fall within these parameters, my lord. In that situation, the affair can be charged quashed. So I am relying upon this judgment where the which says that if the express legal bar has been let down, then there cannot be an affair.
Yes.
There are more or judgment of the same category now, where it has been said that the single package has been found.
Not required.
Because, my lord, I am not in the conscious position, my lord, because the bullet found in the luggage bag, my lord. If I am not having the control of this bullet, then I am not even in the position to control, my lord. That has been dealt in the Guntwal Lal case, my lord, where it has been dealt with regard to the conscious position.
Yes.
Here, my lord, para 13 and 14, my lord. In para 13, which says that the Constitutional Bench of the Honorable Supreme Court in Sanjay versus State it has been observed that the meaning of first ingredient of possession of any arms, it is not disputed. Even though the word possession is not prescribed by any adjective like knowingly, yet it can common ground that in the context of the word possession must mean possession with the requisite mental element, madam. Kindly have a look, madam.
Yes.
Mental element, madam. Thus, in the conscious possession and not mere custody without the awareness of the nature of such possession, my lord. Having the mere custody of my lord, or we consulted custody, it cannot be said that I am having the knowledge to use that ammunition with for any purpose, my lord. In para 14, my lord, the constitutional bench of the Honorable Supreme Court in the case of Gulwanta Lal of State Madhya Pradesh, it was held that the possession of a firearm under the Arms Act, in our view, must have firstly the element of consciousness or knowledge of that possession in the person charged with such offense. And secondly, my lord, secondly, where he has not the actual physical possession, he has none the less the power or control over the weapon. So that is possession thereon continues. So in the last paragraph, it can say the police it has been said that if I am not having the mental element to have the possession, my lord, so I am cannot having the prosecuted, my lord.
Yes. Yes, 950.
Kindly come to again section 45D of the arms.
Yes.
He, the acquisition, possession or carrying by a person of minor parts of arms or ammunition. So kindly see. From this reading, I realized that minor parts of arms, here arms is not applicable, or ammunition.
Yes.
Ammunition, that is live bullet. Or see, minor parts, live bullets contain some ingredients for blasting by arms. Live bullets contain some ingredients and it will be used by arms, that is by rifle. So D is totally not applicable. If some minor parts of a bullet was found, that D was applicable. Suppose bullet contents, if it will be burst after, empty will be remain in every bullet, lordship. In every bullet, empty will be there. 12 bore rifle or pistol or 303, every empty will be there. Suppose empty was found from the possession of the accused, that will be the part of that bullet. That will be that section D. What that section D is specifically written as minor parts of arms. Suppose some barud that contains ingredients was found, means it was not matured bullet for using it by the rifle. Live bullet was found. So 45D not at all applicable in the instant case. Live bullet. Now second part is that not it was a conscious possession. Lordship, my luggage, I have boarded flights. My luggage have been tagged. Sticker has been given. Number has been given. Information received. During the scanning, it was found that live bullets was found. And he confessed, yes, I got from somewhere, some roadside. It is in the charge sheet. If a passenger, if I boarded in a flight or a ship, my luggage was screen checked out. If I will say no, it was not my luggage, he never stated that. So it was conscious possession. Moreover, live bullet was sent to the expert CFS. Supplementary charge sheet has to be filed by the investigation agency. Charge sheet already filed, lordship.
Supplementary is not yet.
Not yet filed. Regarding live bullet, expert opinion is required. Regarding D, lordship, absolutely D is not applicable. Parts I already stated. The bullets contain several parts, which will hit the target. That is different part. Empty will be remain with the gun, and the barud ingredients will be burst. 3 parts of a bullet. 3 minor parts of any ammunition, so that
D is not applicable.
Not applicable.
Absolutely not applicable.
Conscious
And other
possession.
thing, yes, conscious possession, my luggage was secured.
Yes.
I was asked to come during interrogation. He confessed. Charge sheet has been filed. Matter of trial, Lordship. Why question of a charge sheet? Matter of purely trial. Conscious possession, how it was come, all are disputed questions of fact.
Yes.
All are disputed questions. So I pray this petition is liable to be dismissed.
My lord, one short reply. Short reply.
Yes. Yes.
My lord, I have one handed over one judgment, my lord, on Muhammad Nizam, my lord. The same question as my lord, senior has been asked whether the single ammunition will constitute under the.
Would be the part of bullet or not? This is the
My
question.
lord, this question has been dealt with.
Whether live bullet
Yes, my lord. Yes, my lord.
would be a part of bullet or complete bullet.
My lord, the Muhammad Nizam judgment, my lord, which I am on to remember. Here, my lord, the facts is that, my lord, as per the FIR, while the petitioner was traveling from Delhi to Riyadh and Air India bearing number so and so, he was found in possession of one live cartridge, my lord. One live cartridge in his checking in luggage bag, and upon questioning, could not give any valid reasons, my lord. In this case also, my lord, he was found with one live cartridge, my lord. And while he was deciding the judgment, my lord, the paragraph 8, which I have already been handed over the court of the Chang Hong San versus the Arvinder Singh versus State, my lord. In this case, the live cartridge ammunition will comes under the section 45D or not, my lord. It has been let down. While by taking into consideration of that judgment, this has been this judgment has been passed, my lord. In the para 8 and para 9, my lord. Muhammad Nizam judgment in para 8 and para 9, my lord.
Yes, you have referred it.
My lord, my lord. Here, the coordinate bench of this court in so and so case was held that when only a single cartridge or bullet is found in his possession of the offender without any other suspicious circumstances, such possession shall not be enough to prosecute the offender. As a solitary cartridge is a minor ammunition which is protected under section so and so, my lord. It has
minor ammunition and part of ammunition are two different things.
My lord, can you see the my lord, can you see the offense, my lord? Here also a single cartridge is found, my lord.
I am on section 45D.
My lord. Whether the single cartridge will
person of minor parts of arms and ammunition.
My lord.
And minor ammunition.
My lord.
Both are two different things.
My lord.
Minor ammunition,
which I have handed over, it has been clarified, my lord, whether the single ammunition will come under the parts of ammunition or not, my lord.
No, that would be the part of ammunition, no problem.
My lord.
No doubt.
Therefore, my lord, after considering this,
you are intending to take benefit of section 45D.
Not only of section 45D, my lord. Apart from that, my lord, I have to see mental concession, my lord, because, my lord,
conscious possession. Yes.
So, without having found any corresponding weapon, my lord.
I am on 45D. I am on 45D.
My lord. My lord.
And to fulfill the requirement of 45D,
my lord,
you have to show
my lord,
that the person possesses or carry the minor parts of arm or ammunition.
my lord.
So, from your possession, your luggage, one live cartridge was during the course of check-in bag, X-ray and whatever. So, with one live cartridge would come under the minor part of arms or ammunition?
Yes, my lord. For the judgment has been, for that reason, my lord, I have handed over the judgment, my lord, which has been said that the single cartridge will come under the part ammunition, my lord.
Okay, we'll go through with my judgment.
My lord. In para 9, it was stated, in the present matter, only a single live cartridge was recovered from the petition, and the record reveals the petition was not in conscious possession, and it evidently that the conviction remained, and the affair was quashed, my lord. There are several judgments, my lord, where the single cartridge was found and the affair was quashed, my lord.
Yes.
My lord, kindly go through this, the German Chang Hong Sang, my lord,
Yes, it is.
in which that has been let down, my lord. There is the, that.
Paragraph. Which paragraph you are referring to?
My lord. Section, para 23. And para 37, my lord.
The project case revolves around the fact that one live cartridge comes under the category of minor ammunition. So this determination is wrong, na? Minor ammunition and minor part of ammunition are two different things.
No.
Part means one ammunition is may have different parts. Barut part,
Empty part.
What we are telling the pointed part, bullet, pellets and other things. So whether minor ammunition and minor part of ammunition are same thing or not? This is the question. You are correct on your point, but how the question came for consideration, as learned PP has rightly raised, that whether 45D is attracted here.
My lord. Apart from 45D, my lord, I'm to say that
Conscious position is your.
I'm not having the conscious position, my lord. If 45D has been left with, my lord, we have to
So
see
this
whether
question-
I am having the.
This question is pure question of fact.
My lord. My lord.
And such question
There is no premises
cannot be
case
decided
because-
here. Such question can only be decided by the.
My lord, without having any correspondence weapon by the any of the passenger, my lord, whether I am be able to using that ammunition when I am not having the physical control, my lord, whether because the bag was in the luggage, my lord.
Okay, I am
So-
fixing it on Monday. If you can, if you want to file some more cases or
My lord.
more submission, then you can, and then PP can also submit.
On Monday.
Yeah.
Yes.
But very good point of law is there.
What's
Remaining matter is released. एक minute. Now I have to rise. Yeah, partner.
My lord, release for the day, my lord.
Release for the day. Yes. Now I will not come from.
Hope your lordship has an enjoyable weekend, my lord. But my lord is going to Havelock, then